Hey, chat, we are going to get ready. We're going to finish up part 2 of day 16. Let's get to it. Let's get busy. Busy. But yes, we're finishing up Dr. Irini Scorti-Bello, the medical examiner who cut open John O'Keefe. And I don't like the new intro soundtrack. I agree, but I keep telling StreamYard it sucks, but they won't go back. 3 stream Thursdays, yes. So let's get to it, chat. It's time. Here we go. Let's do this.
With regard to what is on the screen,
remember she's on cross and Alessi's doing his thing.
Am I correct that you noted these injuries these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear you.
Ask another question. Sustained.
That's bullshit. She can answer it.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Okay.
So can you answer that, Doctor?
I cannot.
That's a fair question. What could cause this?
You can take that down, Mr. Wolf. Thank you.
Good answers.
Do you
Good
recall
question.
discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No.
Interesting. Really? Consistent with a Lexus that has dog teeth, yes. Yes, he's working on a pattern
here.
here.
You were unable to reach a
well
determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death.
Now that's fair. Your expert's not allowed to say yes, I'm reasonable, and yes, I'm telling the truth. You're not allowed to vouch for yourself like that. He's very sneaky to get it in there. Remember, chat. The jury's hearing these questions and they don't forget them.
Of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it. Asked and answered.
Thank you for answering my questions, Dr. Scorti-Bello.
You're welcome.
All right. Thank you, Mr. Leslie. Mr. Brennan.
Those were very good. That was a very good cross.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If the person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first, for treatment. Many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained as to.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes,
Is it important to have a complete statement rather than just part of a statement?
yes,
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago,
Okay.
but I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes,
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that? Do
Objection, Your Honor.
The doctor can answer that.
you remember, Attorney
Really?
Lucy read you that part of your statement?
yes,
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
I can approach. Actually, take a look at part of your grand jury testimony. Do you remember Attorney Lucy reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go. through it.
Were you asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Can you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes,
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it, turn it over, turn the paper over, please.
I can take it around.
Ask the appropriate questions to her.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes,
And could you share the rest of your statement with the jury, please?
the rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Yep, show Mr. Lesson.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brown.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is,
98 degrees.
so there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on?
This is not really like Hank is trying to battle back. And guys, when you go on, obviously you do direct, then cross-examinations poking holes in what was presented on direct. Coming right back immediately on redirect and trying to rescore those points that the other side just took away from you isn't always sometimes you can't do it. Sometimes you're better off trying to score more points. Like, or just, you may just like write those points off. But like doing this right here is not helping Hank. This is a waste.
On how rapidly a body temperature will drop outside?
The body temperature.
Yes.
Objection, Your Honor, scope.
No, it's within the scope. Let's see if she's got the basis.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body.
It's been snowing all night, and it's below freezing. A guy's only lost 17 degrees of body temperature while he's laying on the cold ground, which is a massive way that will suck the heat out of you. If you guys have ever been camping or slept outside, if you don't have a barrier between you and the ground, it'll suck the heat out of you. So I find it hard to believe John O'Keefe only lost 17 degrees of body temperature in 6 hours in the middle of the fucking winter.
And the higher the gradient between the body temperature and the environmental temperature, the faster the
I agree. He could have probably just said, go home. Have a nice day.
drop will occur.
Because remember, she fucking undermines his case by saying, I don't know what killed him. Yet he's going up there trying to rescore points. It's like, why?
You asked if there was any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Objection, Your Honor.
What?
Sustained. Sustained. Move on, Mr.
What the fuck?
You were shown a photograph, a chalk that had spots on them. Do
What?
you know where that photograph
Fuck?
came from?
I do not.
Do you know who that was
The
from?
fuck
what
is
person
that?
that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information
Why is he
about
doing
what
that? That is
caused
so
the condition that you
fucking
saw on
dumb.
that chalk?
I have
I don't know
seen
why he's going
similar
on with the
pictures
freezer.
in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were
Oh, yeah, Hank's making her
asked
uncomfortable.
about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th.
So your argument is the police didn't do a good job and didn't provide her with enough information. Is that your argument, Hank? Because that's where you're kind of going. You're like, look, this report the police didn't give you is enough to operate off of because the police sucked. Isn't that right, medical examiner lady? You're admitting your case is shit. You're admitting the police didn't do a good job, Hank. This is retarded. Like, you're going for this. This is not going to work. It doesn't work that way because now he's arguing that. It's the defense lawyer in him, I guess, but if you can't fucking turn it off, homie. But yeah, you're pointing out the police only give you 11 sentences worth of information. That sounds like the cops fucked this up even more. Good job, Hank. Good job, Skink Brennan.
It says at 1941.
I have this marked for identification, all right?
Okay.
And in another document.
Let us mark it.
Oh, sorry, let me have that back.
Yeah. Q for identification.
Thank you. May I approach your honor?
Yes.
Second document, is that another document in your file?
Yes.
And is that another report to be considered?
Yes.
How many lines is that report?
5.
I move to have this marked for identification, please.
Okay.
Thank you.
Is it RR for identification?
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I'm going to take the document. I'm not going to actually read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You would ever, well, let me ask you. You submitted the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that
Nuttall.
the defendant
I'm going to allow it.
that the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant?
So so in her 90-day window, she heard, oh, the defendant said she ran him over, and she's like, I can't fucking tell. Notice that's her answer. I hit him, I hit him, I hit him. Okay, well, I don't see a car accident here. Sorry. So it doesn't matter. She refused to call it a homicide. Exactly. Why is he treating her as hostile? Because he's fucking angry. He's upset this isn't working right. Hank is treating her shittier than Alessi is. Yeah, he just wants to keep saying it. He just wants to keep saying it. Remember, if he keeps saying it, it gets in the jury's head.
To Ms. McCabe that she said, may have I hit him? Did I hit him?
Objection, or may we approach, please, briefly?
Okay.
So let's see what they get to here. Sometimes juries are retarded, yeah. Yes, he did not even try to let the information, yes. But you know what? Like, great. That's, but that Alessi should get recross on this, so.
So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scorti-Bello's knowledge and state of mind at the time.
I mean, I don't have 14 days worth of suits, but yeah, I would dress differently every day. You don't wear the same clothes every day. Like, if it's a 1 or 2 day trial, I'll wear the same suit. Why wouldn't I? Like, As long as it's not ruined. Like, yeah, if it's like if it's a couple days, you would try to vary up your wardrobe. So, oh, I'm sure that they want to ask that question, and I'm sure they can get to it on redirect or recross because now it's been opened. I think so very much. I think so very, very much.
Of her report.
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Their observations?
yes,
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead?
Yeah, I was given that information,
And the questions of did I hit him? Were you aware of that?
yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll
How about-
allow that.
You
Yes, I
are
was provided with that.
Bev, you
information.
Were you
bitch.
provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight, she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it
I was not aware of that until much, much later.
after you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware
Would any of that have
of
changed your
voice
mind?
messages left on,
They should be fucking objecting all this. Fuck this guy.
on John O'Keefe's phone from the defendant before
What a
you filed
fucking
your death
asshole.
certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are
He needs to break that down. Do you have experience in pedestrian, like vehicle impacts pedestrians? Do you have experience with the front and the back, like front and the back of a car? Yes. That's how it should have been. That was way too fucking garbagey.
with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that one.
She doesn't know.
How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that one.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes,
And you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
Yeah.
Accept that as your honor.
This is what the fuck is he
Did you
doing?
provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first?
I mean, you're introducing reasonable doubt, Hank. It could be any number of things besides a car. I mean, like, I'd almost like, why did you introduce reasonable doubt here? Why would you do this? Like, I like it, but why are you doing this, Hank? This is fucking retarded. You're introducing reasonable doubt. Huh. The fact he's allowed to lead on these is insane. Yes. Well, redirect is never leading questions. You still have to do your job. So.
aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Thank you, Your Honor.
Good. Get some recross in now.
Dr. Scorti-Bello, this Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol too, you said, right?
Correct, Your
Go right
Honor.
ahead. Yes.
Dr. May I?
Yes.
Dr. Storti-Bello, may I stand by the witness?
Yes.
Thank you. Dr. Storti-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Storti-Bello.
All right, doctor, you are all set.
Thank you,
Thank you
Your
very
Honor.
much. I'm going to see counsel at the sidebar.
That was very good recross. Very, very good. That was phenomenally well. Yes, the pharma degree paid off. Yes. That was very well done. So. That was very well done, chat.
On schedule. So with that, I'm going to let you go a few minutes.
She says that judges are always fucking lying. You don't know if you're on schedule or not. Unless you're doing like a 2-day trial. There's probably still 2.5 weeks of shit left. They have no idea.
It's early, so let us know and be very. So, Mr. Lessie, I'll hear you.
Okay, I guess so. There's something here. I don't know. This is a motion hearing now. I don't know what this is, so let's see. Let's see here what this is. All right, chat. Here we go.
I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welter, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes, that
Okay.
my understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43.
Okay.
And we have been assuming that information, and this is from best memory, but I believe it's slide 137.
That's different. So now Aperture is claiming a different time of when John dies, or the moment he gets struck. Really? So now we're changing up the entire timeline. Wow. Wow, they're really going to change the whole fucking timeline like that? Jesus. Fuck this.
7 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to hear. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that.
Yeah.
Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information.
Yeah.
In terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to
it literally,
so the effect
this
is,
literally causes, how different is it? 5 minutes? No, it's not even 5 minutes, but it changes up the entire timeline they now have to fight. This is complete bullshit. Benjamin says, can they mention this bullshit in closing? Well, they'll have to see. Like, they probably will, but like, the bigger thing is, Bev shouldn't allow this. You can't change your theory like this drastically now after that you've already relayed the information like this. This is bullshit. So like it's so fucking, and this is after the the phone witnesses have been done. Everything's been done. Remember all the timeline shit at the beginning. I guess it does matter now. The timeline shit at the beginning's all done. The timeline's been locked in. They shouldn't be allowed to do this. John Simons, thank you for being a new member, man. I appreciate the support. Thank you.
We still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever
this is entirely trial by ambush.
This is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
Right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a...
And that's important. We're not the state. They can't keep changing the script. They can't keep changing the tune for us to dance to. They're changing the tune, and now how do we dance to that? All the phone witnesses are gone now. They won't have time to get their phone witnesses caught up. Are they going to, this fucks everything up. It should not be allowed.
Rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying.
No, there's no other option. Are we going to continue the case for like 3 weeks? 4 weeks? A month? 2 months? Because let's say they do that. We continue it. Guess what these guys are going to like, our experts came up with more information. No, this is it. Discovery is closed. You don't get the fucking change in the game like this. Hank is running scared.
That I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that.
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
No, chat. There's no mistrial here because you can exclude it.
Okay, continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't given what's been going on. I haven't even had a
Right.
chance to talk to ARPA at
All right,
all.
so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study the case as time goes on.
You literally can't change the entire. You're basically changing the entire timeline. You're literally changing the entire timeline, and all your experts you have don't reflect it anymore. So this is a little more than that. I mean, are you going to have to come in and say my experts aren't fucking right anymore? Is he going to have to throw Whiffen out the window and say Whiffen's wrong? Be really fucking weird to do that.
This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time.
So wait, you're going to have to, so I mean, is this going to be a whole thing where it's like, wait, he completely didn't understand what he was doing before? I mean, this is a tacit admission from the state. Our experts didn't know what the fuck they were doing. They were completely confused. How do we know? Like that's not a good look. I mean, that's something that, you really want to get burned on that in trial. This is such bullshit. This is such bullshit. Like absolute fucking garbage. Island saying, can you imagine sending the jury home for a few weeks and trying to get him back with no media exposure? Yeah. You can't continue this. And if you did, we found more. No, we found more. No, we found more. It would never stop. No, this should not be allowed in. We know she's going to let it in because she's a feckless cunt of a judge. What are the tower building rules? Hella, thank you for 17 months. Towers have to be built as a team exercise. You cannot self-build a tower. If that was the case, anybody could do it. Towers are a team effort. I've said it before. I will say it again. Sounds like future harmless error. Yes.
Estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcome
Absolute
it. We
bullshit.
turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were.
Are we now claiming this doesn't change the data?
Clarified, and it is favorable.
Bullshit, Hank. You were such a fucking liar.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Good. Respond to this
Attorney
shit,
Brennan
man.
has provided a lot of information, and he has accurately
That's saying
provided
nothing.
information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Yes.
Okay.
And he provided that report months ago.
Okay.
So as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right. I thought Burgess was. No?
No, neither.
Okay.
No one from Aperture was.
Yeah, I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained.
Because this testimony changes all the timelines. Remember, they built their case. They built their defense. The prosecution built their case around the time the phone stopped moving. But you know what? Now the phone moved again. And now the prosecution's like, shit, we have to recalibrate. The defense built their case around what the prosecution has. The prosecution can't flex and shift in the middle of trial like that. It fucks entirely with what the defense has done. There's fairness in trial. And this modifies that. This is completely new evidence. You know, given that we're only talking about seconds, but windows of seconds, it's like saying this happened on a different fucking day. That completely changes everything. Completely changes everything.
Hey,
That's why it shouldn't be allowed.
I believe in October of 2024,
Okay.
and at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long. Can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay. Thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARPA materials. What's your argument on that?
I won't iterate the entire passage. Your Honor has found discovery violations. Your Honor has found that the...
Hey, great. They fucked up before, but what now, Hank? What's your tampon attack now?
I want to phrase this properly. Efforts of the defense working properly. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government suggestion and has stated that it's going to allow the defense to proffer 2 expert witnesses in a very complicated field, and an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove this case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wetzel. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th.
That's your fucking problem. Your expert wasn't around. Suffer.
Extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of the material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate.
Well, no shit, your expert's going to say they suck. That's how experts work. But Hank, I don't mean to disparage. Fuck you, you fucking worm. For somebody who's a defense attorney, you got this wormy prosecutor shit down pretty good, man.
The failures of these ARPA witnesses. That's going to take time. You heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He's in a difficult schedule. He is away tomorrow, Saturday. We will go to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, if he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing materials, actively engage his own testing now, so that by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made.
And that's the point. We fucked up. Okay, it's fixed now. You don't get to keep using it as an excuse. Hank doesn't get to act like a bitch ex-wife and keep dragging it up.
And then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have aperture come before the jury, testify to certain things, have ARCA have to come on, and then have aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with aperture, Dr. Welcher and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right. So I have a question for you, Mr. Leslie. Are you still thinking
I agree it's a burn shift. I mean, at some point, like, what the fuck?
that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ACCA is part of that defense, when in that week and a half time frame would that be?
Oh, you gotta be fucking kidding me? She's gonna allow this? You are a fucking horrible judge, Bev. Absolutely dog shit. No. No. Yeah, unless he's the best attorney in that courtroom. This is fucking retarded. This is fucking awful. This is a bastardization of things. Fuck this woman. You fucking little pig-nosed whore of a judge.
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
Well, that's it? You're gonna fucking sleep on it?
Goodbye.
Yeah, that's what's gonna happen to Karen. Goodbye. She's going to prison. God, is there anything she won't let happen? Is there anything this woman won't stop? God damn. She sleeps on everything. She shouldn't. This is easy. No, you don't get to do it. Sorry. You already baked a cake. You don't get to remake it. You know, the cake's already in the oven. You don't get to like scoop out the guts and put a new filling. She's Judge Newman 2.0, yeah. Yep. She's going to fuck them over. She's going to fuck them over. This is garbage. Yeah, a bad judge is the worst because you may be right and she'll fuck it up. And the courts are going to say, oh, well, a bad judge is dangerous. So, oh. Yes, they all need to use Kurt Cobain's microphone to do this. B. Jefferson is right. Yeah, Anna. We found a witness that'll say Karen hit John. We watched it. I'll allow it. They'll allow anything. TLDRs is what happened. The state's basically altering the timeline of when things happened, contradicting their prior experts, and the defense just has to deal with it. So literally the state's almost changing the entire script. And she's allowing him to do it. She's going to allow him to do it. She's not making a decision. She has to make a call and ask what her decision should be. Yeah. So she's trying to dictate the defense's timeline. No. She's saying, like, if they're not going to call it till the end, then it's okay. Because if Hank turns it over before he's finished, they have a week and a half to look at it. This appeal is going to be wild. I mean, the court's going to say, yeah, Bev's a dumb bitch, but we're not overturning it. That's what's going to happen. They'll say, yeah, Bev's a fucking retard. Sorry, we're not overturning. So, yeah. It was within her discretion, yeah. A bad judge will give you 20 years and not give a fuck, yeah. And they won't care that they're wrong. So, yeah, Patrick, you're worried about corruption. This is the banality of it. This is the evil of incompetence for Bev. Bev is not in on the corruption. Bev just sucks. Remember, chat, there's a bell curve, the bell curve. She's on the back end of the bell curve, guys. She's a subpar judge. That's the scary part. The subpar judge, you can do everything right and she'll say nope, and that's it. That's all you got. So State basically admitted that they don't have a case. Yeah, they're going to have to try it. Yeah, this will be harmless error. It'll be harmless error. It'll say it's a discretionary thing and she didn't abuse it. I think the rebuttal one's probably safe on appeal. That surprised May 8th report is less so. She's going to fuck her over. So. She has to see everyone bitching about her, right? She thinks she's in the right. She's a judge. She thinks she's in the right. Doesn't matter. She's a dumb whore. She thinks she's in the right. So. She's on the low end of the Bev curve, yeah. Shugi shows, can they lodge an immediate appeal? They could probably, but I don't think she'll allow them. And Court of Appeal is going to say, yeah, just bring it up later. So. Have I seen Bev in the other trial? I know there was the bench trial, but listen, that's it. From what I understand, that was a pretty easy fucking case. This is the one that matters. The chips are fucking down on the table. This is it. This is Friday night. It's under the lights and she's acting like a fucking retard. No, I'm not impressed with this woman. Great, she got it. She made the right calls when it was easy and obvious. Then when the fucking rubber meets the road, she fucking acts like a retard. She's such a fucking dumbass. So, yeah. Bev played up the ARCA thing for this reason. Yeah, I don't know. We'll see. I don't give her that much credit. She's a tard. Meaning mid-trial appeal or decision. I don't think they're going to allow an interlocutory appeal. Bev won't allow it. They'll have to file it anyway, and the Court of Appeals is not going to take it. So. Yes, the banality of Bevel. Bevel. This is just, she's just fucking incompetence is so dangerous. So dangerous. There's no escaping an idiot, yeah. She knows what she's doing. It ain't incompetence, I guess. But she's a fucking awful person. Durna is saying for $5, she's high on the job, but she's got a prosecutor in the room. How do you think she's going to act? By doing the right fucking thing. She's not even a prosecutor. He's a pretend prosecutor with a pretend case. Yeah. Brady violations aren't a big deal, though. Blockish Owl says, how do you explain this to the jury? I don't know. I don't know how Hank's going to explain this. So, yeah, this comes after the Court of Appeals, the First Circuit smacking her down. Yep. And then the district court smacking her down and forcing her to rewrite the order. Yeah. If this happens, Karen Reed's chances of conviction are like 75% minimum. If they're allowed to do this, it's going to fucking... Karen Reed's conviction rate is just going to the fucking moon. So... She better allow robust cross. No, she's not. She fucking guarded Scorty Bello. So no, she's not going to allow it. She's a cunt. Yeah. Yeah, Hank's going to claim that, and she'll probably allow this. And the defense is making stuff up. They even use the wrong times to confuse you. I'm sure she'll let that in. The defense needs to move for her to be recused. She won't. There's not enough bias there. It won't work. Nothing you can do about that. So, did I go over a new buffer order? Is it on Twitter? Let me see. Because I don't have it. Let me see here. Karen Reed buffer zone. Okay, yeah, I have it here. Hold on. Okay, so we'll bring this up. So the buffer zone around the courthouse happened. What if Bev was assassinated? I'd fucking do an Irish jig. I do an Irish fucking jig. How can this be remedied? Well, nothing's happened yet. Nothing's happened yet. But we know Bev is going to fuck Karen Reed over, so... Yeah. Turtle Boy covered it. Well, I'll cover it too. So 86 Bev, yes. Somebody hit Bev with a fucking car. Okay. So this is a supplemental order regarding the buffer zone. And it says, this court is in receipt of the decisions from the First Circuit. Notice that is the dick slapping. This court is in receipt, meaning I understand, I have it in my hands. I have it in my hands from the United States Court of Appeals for the First Circuit in Grant v. Trial Court of Commonwealth of Massachusetts. To simplify any issues, this court is guided by the Court of Appeals suggestion and issues the following supplemental order. Notice she says from the Court of Appeals' suggestion set out on page 12. This was their way of saying, change this, you dumb fucks. It says, first, for all the reasons cited prior and based on the parameters, all orders of this court remain in effect so far as they apply to courthouse property. Prior orders remain in place as applied to pathways, including public sidewalks and roads, through which at times trial participants enter and exit the courthouse. Okay. Third, noisy protests, including those using amplified sound, honking horns, or loud screaming and yelling that are intended to interfere or influence anyone, are not allowed. Fourth, the display of written or graphic materials. Oh, hold on. Can you guys see this? Because you guys are going to like scream at screen here. Fourth, written display of graphic materials that are intended to interfere are prohibited. Okay. Fifth, any person whose activity has been restricted by an officer enforcing this order may request a view by the judge of Superior Court, which request shall be heard as expeditiously as possible. Okay. Quiet off-site demonstrations on public property in areas and at times that do not interfere with the participants. Entrance or exit from the courthouse and do not interfere with the orderly administration of justice and are not intended to influence the trial. Participants in their duties. Are specifically outside the scope of the buffer zone restrictions. So exactly, Bao, the guy who got arrested, he's allowed to be there. You just can't be loud and disruptive. Otherwise, you're allowed to be there as long as people aren't walking in and out. So it's been very much simplified. Peter Key says, are cops blasting their sirens not for support? No, it's because it's the police station and fire department are nearby. So, Turtle Boy has the God-given right to be himself. Yes. I hope she's being investigated. Yes. The orderly administration of justice, like she knows what the fuck that means. Yeah. Order them pizzas. No, don't do that, chat. Don't do that. All right. Ah. That's funny, though. That is very funny. Oh. So there we go, chat. That is the updates. Those are the updated. Orderly, hurry up, Miss Alexis, Mr. Alexis. Yes, Dylan from the alternate corner. I didn't know he was in Boston, but yes, Dylan from the alternate corner, guys. I know we talked about him last year. It's been a while since I talked to Dylan. It's good to see him. He looks like he's doing well. By the way, is out there in Boston, like fucking hanging out at the courthouse. It's pretty cool. Why can't the jury order pizza? Well, the court has to order it for them. But the court's in charge of getting their meals set up. Yes, Dylan is over in America, yes. The feds come for the Commonwealth. I hope so, but that ain't going to happen. That ain't going to happen. Melanie said the fire department's in favor of Karen and they blast the sirens in support of her. Well, are they? Well, a couple of the people in the fire department are fucking rats. It sounds like. Sounds like they're a bunch of rat motherfuckers. They must not like those people, like Nut All and them. So, I heard the 1.0 jurors brought coffee to the buffer zone today. That's hilarious if they did. So, Hella says, okay, we'll invite him on stream on Saturday. Yeah. Yeah, no, Dylan's a good guy. The Alternate Corner, guys, it's a very good streamer. Joe Moore says, who's Melanie Little? She totally blew up this year. Yeah, she's an attorney. She's been doing it for a long time. Very, 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 very battle seasoned attorney out of New York. She's great. Very good coverage. Very good comments, too. I appreciate them. She does good work. I like it. 12th Monkey says, honest question, how does changing the timeline increase the chance of conviction? Because all those discrepancies, the defense pointed out, the prosecution could say, oh, the clocks just don't work right. And therefore, they wipe it all out. That's why. Literally, all the stuff the defense has done now, the prosecutor can go like this, wipe it off, doesn't matter. That's why. They could, because, like, think about it. It's like you're shooting at a target, and the target can move. Like, it's stuck in the ground, but it can do all the Matrix shit. Well, that's not fair. How do you fight? So that's the thing. That's the thing. So that's how this, like, that's the problem. Think about it. If you're a defense attorney and I could just change up my fucking case every 5 seconds, you're fucked. There's no way you could fight that way. There's no way you could fight that way. Andrew in the day, Sean at night. Melanie's doing 20,000 live views a day. Yeah, Melanie's crushing it. Mickey says, do I believe in pausing habeas corpus? Absolutely fucking not. Absolutely fucking not. So, absolutely not. Melanie did a lot of work against the PDFs in the Catholic Church. Ooh, did not know that. So, yeah, the state's case needs to be set in stone pretty much at the beginning. Yeah, unless something like, shocking comes out. Yeah, like they should be able to prove their case. It's not the defense's fault that they found all the holes. Yes, guys, we pretty much don't have control over if there's ads popping up in the streams anymore. I set it to like minimal, but I'm not in charge of that. Like YouTube runs those. So, Hatchix. Oh yeah, it's the Dedham Fire Department, not the Canton Fire Department. So fair enough, fair points. Yeah. YouTube is asshole. Yes, it is. YouTube is asshole. Yes, it's no longer a direct hit. It's a glancing blow. Yep. So, it says for 20 million illegals, how do we give the invaders their day in court? Hire a bunch of fucking judges. I mean, it's not hard. Immigration hearings are not hard. They're not like a regular trial. You hire a bunch of immigration judges and you can burn through like a bunch of them in a day. You can make an assembly line. You can make it an assembly line. It's not that fucking hard. And once one person raises an argument and it fails, other people, like, it's easy then to disprove them. So it's not like you have a 15-year trial or something. So it's easy enough to afuera them. Afuera. Hastrick says YouTube is an asshole and I spend all my spare time with them. Yes. So there's nothing we can do. The Supreme Court says they get due process, then they get it. So, yeah. Why do we get classes for their benefit and we can't use classes for their removal? Because each person can be different. They have the right to prove why they shouldn't be taken away. So, Jordan says classic response. I mean, they're fucking administrative law judges. It's not that big a deal. Hire a shitload of them, then fire them all. Use the money savings. Actiony Hammerish V saying, imagine how much time it take to deport 30 million people. Ridiculous, huh? Well, got to start somewhere. Eat an elephant by one bite at a time. So, yeah. So that is it, chat. It's 1:15. I'm gonna go to sleep because I gotta be driving tomorrow. So, In before Doge implements AI lawyers, so then it's never going to happen. Yeah. The AI hallucinates too much. Yeah. Yeah, due process is a hearing before an executive branch administrator. A immigration judge is an employee of the Immigration Service. It's not a federal judge, chat. It's not an Article 3 judge. You guys are so worried about this. Hire a bunch of examiners and then fucking flare the shit out of people. So, yeah. So, you don't have to eat the whole thing. And if you eat the whole thing, start with the butthole. I'd rather pass on that. So, you're not thinking we can deport 30 million. You're right. We probably can't, but if we can get rid of half of them, great. If we can only get rid of 10 million of them, fine. Whatever. Just because it's hard, just like Kennedy said, we don't do these things because they're easy. We do them because they're hard. Oh, well, fuck, there's too many of them. We just give up. No. Afuera as many of these cocksuckers as you can. Afuera the fuck out of them. It's not hard. You go. Mickey says you can't do it in an orderly way. Then you do as many as you can. Sorry, but them's the rules. We got to do it orderly. It's easy enough. It's easy enough. Joe Lloyd says, take care, Sean, and focus on tomorrow. Lol. Yeah, tomorrow's going to be easy. Just got to, I'm going to spend it's probably like a 2-hour drive. I'm probably only going to be there for like 30 minutes and then a 2-hour drive back. Fucking awesome. I've done it before. You drive like 3 hours and then you show up for court and you're like, oh, just like, yeah, okay, yeah, here we go. 10 minutes and you're done. You're like, well, that was whoa, my camera just fucking lagged up. Just sleep through it. Oh, Seraph is sick? Oh, no. Oh, Hella's kitty's not feeling well. I hope your cat feels better, Hella. Guys, remember Hella doing Hearsay for Days, but also Zachariah Anderson on Saturday. I don't know what time because she hasn't said yet, but she'll be covering it on Saturday. And I will work around that with my Supreme Court stuff. So. That will be the game plan. I turned into Orange Man. I did? Jeez. Well, whatever. 7 p.m. Eastern, chat. Okay, we won't have to work around that. 7 p.m. Eastern on Saturday. Zachariah Anderson. So. With that said, chat, we are all done for today. We will start again day 17 of Karen Reed tomorrow. What time does Josh Moon stream tomorrow? Maddie's at noon. Maddie's at 12 noon on Rumble. So my camera regooch the light balance. I'll have to fix it in a minute. So, but with that said, chat, yeah, the second anniversary is a conviction. Yeah. So, yes, it's 12 p.m. Eastern time for Maddie on Fridays. So, tomorrow is going to be packed, chat. Yes. So, chat, with that said, until next time, and thank you for all the over 300 people here. Just because you did it does not mean you're guilty, and does not mean Karen Reed is guilty. In fact, I think Karen Reed's still innocent. So, we shall see. We shall see. Bev allows this shit in, though. Karen's odds of getting convicted just take off. So, really hope it doesn't happen. But fingers crossed she does the right thing. Good night, chat. I will see you guys tomorrow.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops. even when they nab you on illegal stops. Just 'cause you did it doesn't mean.
To be fair, it probably is safe to let Karen drive you around. Just don't leave her in the car in the driver's seat when you get out. That's the danger. Being in the car is safe. It's very safe with Karen. Think about it.
You're guilty, but please talk to a local attorney. Was that the